Well, hi, everyone. Thanks for joining us. It's 11:59, so I think we might as well get started. It looks like we've got lots of people signed in. Thank you very much for joining us for this Lunch and Learn. My name's Bria Dabbs, and I'm a legislative counsel with the Government of Yukon and also a member of the Continuing Professional Development Committee for the Law Society of Yukon. And I'll just quickly go over the format for today's event. We've got an hour and a half, so because it's fairly short, we won't take any break partway through. And the Justice Wenckebach has said that questions are welcome throughout the presentation, but because of the number of folks registered, if you can just actually write your questions out in the little Q&A box and instead of turning your mic on and camera on, I think that would be the most efficient. And then I'll keep an eye on the question chat box and just interject with questions as they come in. So I am very pleased to introduce our speaker for today, Justice Wenckebach, who was recently appointed to the Supreme Court of Yukon. Before that, she had a varied legal career. She worked for many years with legal aid in the areas of family, criminal, and poverty law. She then worked at the Government of Yukon. For a brief period, she was part of the solicitors group before the siren call lured her back to litigation. While in the litigation group, Justice Wenckebach practiced primarily in the areas of labor, human rights, and administrative law. Justice Wenckebach was also on the executive of the Law Society of Yukon for several years, and then became a member of the Discipline Committee for the Law Society. Justice Wenckebach has a keen interest in administrative law and loves a good judicial review. So Justice Wenckebach will be speaking today on the importance of reasons in the age of Vavilov. So with that, I would like to say thank you very much to Justice Wenckebach for joining us, and I will hand it over to her.
Thank you, Bria. So I got an invite on the Zoom, and I don't know if you got the same one, but it says something about me giving you practical tips for judicial review. And I have to say, I did my presentation before I read the assignment. So it's not focused on practical tips. It's rather a deep dive into reasons. But I do hope that there are some tips along the way with regards to judicial review. So Vavilov is known generally, I think, for reviewing the standard of review and coming down quite firmly with regards to that. But in my opinion, that's actually probably the least interesting or maybe impactful part of the decision. There's an awful lot in there, and one of the things that's really important with regards to Vavilov and what it does for administrative law is it puts a focus on reasons. So with that, before we get to Vavilov, I'm going to take you back, way back into the past, and we're going to do kind of a whistle-stop tour of reasons with regards to administrative decision makers. So before 1999, there was no general principle that there was a requirement to give reasons as a part of duty of fairness. Some lower courts found that sometimes there was a duty to provide reasons, but others did not. And the Supreme Court had not come down and said that reasons were required in some instances with regards to administrative decision makers. But then in 1999, the Baker v. Canada came before the Supreme Court. Mavis Baker, so the facts are that Mavis Baker was from Jamaica, a citizen of Jamaica. She came into Canada as a visitor and then overstayed. She started to live in Canada. She worked in Canada, had kids, and also became quite ill. But she was here illegally. And at some point she got a deportation order issued against her. At that point, she applied to be admitted to Canada on what's called humanitarian and compassionate grounds. And that's an exception to other modes of entry into Canada, that it provides an exceptional circumstances where people will be admitted into Canada, particularly when they're here illegally. Now, she was denied. She judicially reviewed the decision, and it went all the way to the Supreme Court. And there were a lot of issues that were dealt with by the Supreme Court, but two of the issues were reasons given and are reasons required in administrative proceedings. So the first question is actually kind of interesting because at the beginning, Ms. Baker was not provided with reasons at all. And when she asked for reasons through her counsel, she got the notes provided by an immigration officer to the officer who ultimately made the decision to deny her entry into Canada on agency grounds. And so the question was, were those notes reasons? Now, the notes from the immigration officer that advised the decision maker, I've cut and pasted some parts of it. It says, PC is unemployed, on welfare, no income shown, no assets, has 4 Canadian-born children, 4 other children in Jamaica, has a total of 8 children. This case is a catastrophe. It is also an indictment of our system that the client came as a visitor in August 81, was not ordered deported until December 92, and in April 94 is still here. The PC, and that's Mavis Baker, of course, is a paranoid schizophrenic and on welfare. She has no qualifications other than as a domestic. She has 4 children in Jamaica and another 4 born here. She will, of course, be a tremendous strain on our social welfare systems for probably the rest of her life. There are no agency factors other than her 4 Canadian-born children. So aside from the fact that the Supreme Court of Canada was very unimpressed with the quality of the notes, they did decide that these notes constituted reasons. And in doing so, they acknowledged that administrative decision makers are in a different situation than courts are. They're going to be more pressed for time. They do things on a routine basis. And so they're not going to provide the kind of decisions that courts do. So in this case, even though a lot of the decision is kind of short form, there are all caps throughout it. And it was given to somebody who adopted it as their reasons. The Supreme Court of Canada decided that this was sufficient to constitute reasons. Now, the other thing they talked about was whether procedural fairness requires that reasons be provided. And as usual in administrative law, even more so than most of law, the answer is sometimes, and it depends. Sometimes the duty of fairness will require that reasons be provided. And the determination of whether reasons are provided is based on the Baker factors. And I won't go into the Baker factors now, but we'll talk a little bit more about them later. All right. So the next stop on our whistle stop tour is 1999-2011. And this might be known as the era of adequacy of reasons. Courts kind of took Baker and a little bit ran with it. They took Baker to mean that where reasons are given, they must also be adequate. There is some disagreement between courts about what adequacy of reasons meant. The federal court said that adequate reasons do not simply recite the submissions and evidence of the parties and state a conclusion. They set out the findings of fact and the principal evidence to the decision, identify the major points in issue, explain the reasoning process, include the main relevant factors, and providing adequate reasons is a component of duty of fairness. So if you don't comply, or if the decision maker didn't comply with one aspect of these, then their decision was overturned. And that's because duty of fairness, the standard of review is correctness. Ontario and BC took a slightly different approach, and there was almost a two-step analysis. On the one hand, once it was determined that reasons were required and reasons were given, adequacy was assessed on an intelligibility scale. So if they were intelligible, then they passed the adequacy test. But then they went on, and if there the more deeper issues were conducted, or analysis was conducted on the substantive review. And so that would be conducted on the standard of review of reasonableness or correctness, depending on what standard the court had decided was required at that time. So this happened until 2011, as I said, because the Supreme Court of Canada then came down with Newfoundland and Labrador Nurses Union versus Newfoundland and Labrador. And it came down with a thud. Now, arguably, and I think in Vavilov, the Supreme Court tried to salvage Newfoundland nurses a little bit, but I don't think successfully. Arguably, Newfoundland nurses put reasons on a completely different track. What they said, essentially, was that whether or not an administrative decision maker had the obligation to give reasons was a component of duty of fairness. But the adequacy of reasons themselves is not a component of duty of fairness. And it is not a standalone ground basis for overturning a decision. What Newfoundland nurses directed courts to do was to show deference to the decision maker, and in a sense, show deference to their reasons as well. So what they said was, if the reasons allow the reviewing court to understand why the tribunal made its decision and permit it to determine whether the conclusion is within the range of acceptable outcomes, the Dunsmuir criteria are met. And in doing so, what the implication that was taken, I think, was that whether or not it was meant I think it was meant, but some people may disagree, is that courts should not be looking at the reasons very closely. The level of review, the amount of scrutiny is quite loose. And if you can kind of see where the decision maker was going and why they went there, then that's sufficient. And the other thing that they said was, even where the reasons do not wholly support the conclusion reached, it may still stand. The court must first seek to supplement the reasons before it seeks to subvert them. And that statement, the court must first seek to supplement the reasons before it seeks to subvert them, got quite a bit of traction. And I'm sure you can imagine, or maybe you were involved with this, that there was a lot of case law about what does that mean to supplement the reasons? How far does it go? Do you fill gaps? Do you correct errors? Are you just looking at the record to understand a little bit further? So in terms of supplementing, it was usually from the record, and the bigger question was, what does that actually mean? This was clarified in Delta Airlines versus Lukash. Now, Mr. Lukash was an advocate for, or is an advocate for, airline passenger rights. And he filed a complaint against the Canadian Transportation Agency, with the Canadian Transportation Agency, against Delta Airlines on the basis of their policy around finding seats for people who are obese. And he argued that the policy was discriminatory. Now, Mr. Lukash was not personally affected by this. He was doing it on behalf of other passengers. So the Canadian Transportation Agency, what they had to do was determine whether Mr. Lukash had standing to make the complaint. And they determined that he did. They took the common law test for public interest standing and determined that he did not have standing. This made its way to the Supreme Court, and the Supreme Court took the opportunity to clarify what they meant in Newfoundland nurses by supplementing reasons. So they said that supplementing reasons may be done where the reasons are non-existent or insufficient. While a reviewing court may supplement the reasons given in support of an administrative decision, it cannot ignore or replace the reasons actually provided. So there's no fixing mistakes, no filling in gaps. It's much more restrictive than some courts took it to be. The majority in the decision actually determined that the Canadian Transportation Agency had been unreasonable in their application of the test, and determined that they had not applied the test given with regard to the context of the situation. So the test requires that, the test looks at how legislation applies to the applicant, but the Canadian Transportation Agency doesn't deal with legislation. It deals with carriers, and carriers have policies and procedures. So the Supreme Court concluded that they simply applied the wrong test, even though it was the common law test. Now, interestingly, there was one dissent, and that was Justice Vavilov, who said that the Canadian Transportation Agency could create whatever test they wanted. I may be paraphrasing a little bit, and that there was no reason to interfere with the decision. But that all changed with Vavilov. And Vavilov came down like a year after Lukash did. So Vavilov, from the beginning, everyone knew that Vavilov was a big deal. When it granted leave, the Supreme Court asked the parties to devote an extensive part of their submissions to the question of judicial review and standard of review, and invited a number of interveners to intervene on this issue either. So they basically said, we're going to take a good hard look at standard of review. And they did. They reviewed it from top to bottom. They addressed when reasonableness applies, and in case you don't know, it's basically the default standard. There are a few exceptions, but they're going to be the rare situation. They defined what reasonableness is. Again, this has been going on since, I think, the 80s. So hopefully we now know what reasonableness is. But what's important here is, let me see if I can do it. No, here we go. Highlighter. All right. I'm going to be looking at the analysis of reasonableness is based on the reasons and the creation of a framework for analyzing reasons. So Vavilov said that the reasons are central in assessing whether an administrative decision maker's decision was reasonable. And this is a quote from the decision, is the starting point for our analysis is therefore that where reasons are required, they are the primary mechanism by which administrative decision makers show that their decisions are reasonable, both to the affected parties and to the reviewing courts. And what this does, I think, is it takes what was done previously and rejects it. And that is, I think that there was a tendency, even if it arguably wasn't in the Supreme Court of Canada decisions, but there was a tendency to focus on the outcome. If the outcome was reasonable, then there was less analysis of the decision itself or the reasons themselves. And the Supreme Court here is saying that decision makers have to explain their decisions, and they have to do it in a way that the courts will accept. Okay. And they gave two aspects to assessing whether reasons are reasonable. And this is the framework that they provided. First of all, the reasons must be based on an internally coherent reasoning. And secondly, the reasons are justified in light of the legal and factual constraints that bear on the decision. So with regards to internally coherent reasoning, this is, in some ways, this is not this is not a difficult area to understand. It's something that courts and lawyers are very comfortable with. They did say that reasonable decisions don't just simply repeat statutory language, summarize arguments made, and state a peremptory conclusion. And reasonable decisions do have a chain of analysis. What unreasonable decisions have is they fail to reveal a chain of analysis or reveal that the decision was based on an irrational chain of analysis. So this is where you look at the decision and there are leaps of logic, for instance, or tautologies within the decision. If that occurs, then there can be a chain of analysis that is irrational or faulty. And then you also have to take a look at, because the issue is always whether the decision itself is incorrect, is whether that affects the decision. So if it's a corollary issue or a minor issue, it may not affect the decision. Unreasonable decisions reach a conclusion that cannot follow from the analysis undertaken. And as I was researching this, I came across the perfect example of this. And this was a person who applied for a stay of his deportation order to the federal court, and not to the federal court, but it was reviewed at the federal court because it was stayed, and the government took issue with that. And in that case, what the board who made the decision said was they summarized all the evidence in terms of all the bad things that the person had done. And basically kept saying, oh, this is bad. Oh, this is very bad. Oh, this is so bad. But then stayed the deportation order. And so the natural conclusion there would have been that the person should have been deported. And that was the decision that the federal court reached, that the decision was, at that point, they decided under adequacy, but here it would come under an unreasonable decision. Now, it's possible that that decision would have survived a judicial review, potentially, if they had explained why they had given the person another chance. But The failure to do so was lethal. So unreasonable decisions also state that when read in conjunction with the record, do not make it possible to understand the decision maker's reasoning on a critical point. Now, you'll notice that in Vavilov, they said, they didn't say you can't look at the record anymore. And there seems to be a little bit of a continuation from Newfoundland nurses, which allowed you to look at the record to understand the decision. So what I'm going to do is I'm going to put a pin on that part about what role the record plays, because I'll be looking at that later. Now, finally, the court warns that, or the Supreme Court warns that the court should not engage in a line-by-line treasure hunt for error. And that's that statement goes back a long ways. And it's pulled out often because ultimately the issue with reasonableness is that it can run the gamut. So Rosalie Abella's approach to reasonableness is much less, encompasses much less scrutiny than the Supreme Court does, than Vavilov does, the majority of Vavilov does. But what they're saying basically is that you're not looking for an error. What you're looking to see is how the decision comes together. So the second part of the analysis is that the decisions must be justified in light of the legal and factual constraints that bear on the decision. And so I have to confess that in reading that felt quite difficult to wrap my mind around what it meant by legal and factual constraints that bear on the decision. As you read the decision of Vavilov, it states, it explains it further to state that a decision must be justified in relation to the constellation of the law and facts that are relevant to the decision. So ultimately, I think that all it's saying is that the decision has to be made in light of all the facts and the law that impact on the decision, which is sort of should be self-evident, I would think. But what's more interesting and what they've done, what was new, was that they provided guidance with regards to how a court is to undertake the analysis of reasons to determine whether or not they are reasonable. And they specify that you don't have to go through every single one of these factors, but there are times where some will be required to be used when analyzing reasons. So the elements for evaluating reasonableness are the governing statutory scheme, statutory or common law, principles of statutory interpretation, the evidence before the decision maker, the submissions of the parties, past practices and decisions, and the impact on the affected individual. So I'm going to go through these one by one. The governing statutory scheme, they stated, was likely the most salient aspect of the legal context to the decision. And I think in some ways, this is a little bit of the analysis of what we used to do under the standard review to determine whether something was reasonable or correct, or if you're old enough, patently unreasonable. What they also said was it will provide the nature and extent of the decision maker's discretion. The legislation may place specific constraints on the decision maker, the decision maker, and the scope of authority may allow the decision maker to interpret legislation more broadly or narrowly. So as I was saying, I think this is where the kind of analysis that happened under standard review would come in. So it may be that the privative clause is no longer a major issue, but it may also be that this is a situation in where you would look at whether or not there was a privative clause. Also, you would look at the language of the legislation. If the legislation uses broad language like at the discretion of, or in the public interest, will make a decision in the public interest, then this indicates that this decision maker not only has the ability to make different kinds of decisions or a broad scope of decisions, but you will have the ability to use different kind of factors in coming to their conclusion, and has a broad scope in terms of that as well. On the other hand, if legislation tightly prescribes the decision maker's discretion or the kinds of factors that the decision maker will use, this will narrow the amplitude of the kind of decision that a decision maker can make. Now, the second, and one thing is, by the way, I can't see anybody because I don't know how to, I can't make my,
I don't think that you'd be able to see anyone.
Okay.
Just to think about, yeah, everyone's got their cameras off. So, but I am watching.
Oh, everybody's got their cameras off anyway.
I think, or so, yeah, we're not able to see anybody else. So,
so I mean, the problem is that I don't know if you're getting me or not, or if you're following me. So, feel free to ask questions.
And I have the questions, so I'll interrupt if something comes in for you.
Okay. All right. So the next category is other statutory or common law. And the Supreme Court here said that a decision maker cannot ignore statutory or common law. Precedents on the issue must be considered, and where not followed, an explanation must be provided. And however, common law principles may be adapted to the specific administrative context. So in terms of common law, Lukash is a really good example of this. In that case, the Canadian Transportation Agency adopted the common law test, but then didn't modify it to its circumstances. Had they come up with their own test under Vavilov, that would not have been correct or reasonable. And in this way, actually, what it really does is it puts to rest kind of the abelian approach to addressing reasonableness, where tribunals have a lot more flexibility and ability to go beyond what has been done by courts. Now, with regards to statutory law, this would be things like phrases that are commonly known and commonly defined, and tribunals are required to take that into consideration when making their reasons as well. Now, one of the things that I find interesting with this is that it kind of presumes knowledge of the common law by the administrative decision maker. In a lot of administrative law, we're dealing with lay people who make decisions, and the parties before them are unrepresented as well. So not a lawyer in sight. And the question is whether, given that those tribunals will be required to know the common law, or research the common law when issues come up. Or whether, in some circumstances, the tribunal can rely on the fact that it was not presented to them, and therefore they didn't have to make a decision on whether common law or statutory law applied.
And sorry, Justice Wenckebach, just to interrupt here, there is a question. They did say it could be for later, but I might as well ask it now. So we've got legal and factual constraints. Is it enough for the admin tribunal to say that they need not follow a particular decision solely on the basis that it was made in a criminal rather than admin context?
In some circumstances, they might be able to. The more important the issue and the closer the administrative context to the criminal context, or then they would have to actually explain. Likely, I mean, it's difficult to talk about in the abstract, but likely it would be sufficient to say that criminal law is, there's a finding beyond reasonable doubt, which is not something in the administrative law context. Therefore, you don't need to take it into consideration. Now, say, for instance, there's a finding of not guilty on something. They could do that. But they would certainly have to do a lot more explaining if there was a finding of guilt and there's an issue about whether the person is guilty at the administrative tribunal, and the tribunal decides to retry the issue themselves or not accept the criminal decision. I think actually that would have been the same before, and I think that has been discussed at the Supreme Court. It happens frequently, often in the labor law context, where somebody is being fired because of a criminal conviction. I'm just going to read the next question. On the point of common law as a relevant factual constraint, do you think that a decision could be found to be reasonable if the decision was contrary to the common law with respect to a judicial interpretation of provision in the administrative body's home statute? I think it'd be very hard for it to be reasonable. If it's a judicial interpretation of an administrative decision, what the judicial interpretation is saying that the legislation itself, that interpretation, the interpretation that was brought out by the tribunal was unreasonable. So it'd be pretty hard to go contrary to whatever the judge decided and say this is also reasonable. Now, if it's a home statute, but it's a different context, I think under Vavilov, it would probably still be difficult to argue that it's reasonable. They'd have to have pretty good reasons to depart and say why the context is different in this case than what the judicial interpretation was. I hope that answers the question. Okay. Now, going on to the principle of statutory interpretation. So what the court is saying here is basically that the form that statutory interpretation takes when conducted by administrative decision maker can be very different than that done by a court. It may not look the same as what would happen if a court were to conduct it. And they may employ different factors or look at the question in a different way than the court would. And Vavilov states that that's not a problem, that actually enriches the experience or enriches the interpretation. But then they're quite clear on the next point, and that is, they say, but whatever the form the interpretive exercise takes, the merits of an administrative decision maker's interpretation of a statutory provision must be consistent with the text, context, and purpose of the provision. So you may note in there's a little bit of Rizzo and Rizzo there, and that's because that's what it is. The court is saying they still have to apply what the courts would apply in terms of the legal interpretation of a statute. They have to look at the text, they have to look at the context, and they have to look at the purpose of the provision. And again, this is actually something new in terms of the fact that the Supreme Court is clarifying it. That decision makers have to have facility with statutory interpretation to the extent that they know the test, and how they apply it may be a little bit different, but they have to actually know the test. And if they don't, if a decision doesn't look at text, context, and purpose, it's vulnerable to judicial review. So with regards to the evidence before the decision maker, what the reasons have to show is that the reasons basically have to apply the facts, and in the same way a court would really, and show why they come to the conclusion they do based on the facts. Now, again, it may not be exactly the same as what the court does in the format, and they may do it in a way that's different than the court does. But what I take from it is that there has to be good attention to facts. And hearkening back to earlier, you can't just recite the facts and then state your conclusion. You have to talk about how your facts apply. Now, in terms of a judicial review, I think that what the issues that arise if you're going to be challenging what the decision maker's reasons with regards to facts is if they don't include certain facts, how important those facts are to the ultimate decision, or how important they are to the analysis. And when adequacy of reasons was in its heyday, that was where that contention would come up. Okay. So another factor is that the court will look at is the submissions of the parties. And this is similar to evidence. The decision maker must show that they have meaningfully accounted for the central issues and concerns raised by the parties. But the decision maker is not required to take into account every argument before it. So again, on judicial review, the issue will be, is the issue important? Did the decision maker have to take this into account when rendering their decision? Now, in outlining why this is important, what the Supreme Court said was that it's important so that the decision maker can show to the parties that they have heard and understood their arguments. So in that case, it's the assessment of reasonableness isn't so much about isn't about the analysis. It's about reassuring the parties. It's about what it looks like, what it looks like to the parties rather than what the substance is. And there is another part where they talk about how it can also help the decision maker realize where they might have issues. But I would say that the primary purpose is really for the appearance's sake. The inclusion of issues is also important because it shows the chain of analysis. And so likely, if you're looking at this ground, there's going to be some overlap with whether or not there's a rational chain of analysis, rather than whether the decision maker looked at all the legal and factual constraints upon them. And a third thing that I think is interesting here is what happens if the issues aren't raised at tribunal level. So Vavilov really said this is about taking into account the central issues and concerns raised by the parties. What if there might be an issue there that isn't raised by the parties and the tribunal doesn't look at it either? Can this be raised by a lawyer on judicial review? Does the tribunal have an obligation to raise issues? Maybe sometimes they will, and maybe it'll depend again on who the tribunal or decision maker is. Okay, so looking at past practices and decisions. Now, I didn't watch I didn't watch the Vavilov, although I probably would have enjoyed watching it when it went to the Supreme Court. So I didn't see the oral submissions and I didn't read the written submissions, but I understand that one of the concerns that were raised by the interveners and has been raised in other areas is that what will happen in a tribunal setting is that two lines of case law will develop, where certain faction of the tribunal members go one way and another faction of tribunal members will go another way. And
sorry, Justice Wenckebach to interrupt. I just have a question. I should have clarified this at the start. Is there would we be able to get a copy of your slides?
I'll send it
share
for sure.
Participant?
Yeah.
Okay. Perfect. Okay, thank you.
So some of the submissions at the Supreme Court were that the standard of review of correctness should be applied in those kinds of situations where there was this division and there wasn't any kind of reconciliation or attempt to try and find a common ground. And the Supreme Court rejected that, standing firm on standard of review being reasonableness most of the time, but said that even though administrators are not bound by their previous decisions, they should try to be consistent with policy directives, internal legal opinions, test cases, things like that. And if they depart, then they better be clear to explain. They better explain why they're departing from that. So I'm not sure how satisfactory that answer is. They did say that if there is continuing problems, then they really do need to resolve it, but they didn't really establish how. And then, finally, we're at the impact of the decision on the affected individual. So where a decision is significant to an individual, a decision maker will be required to explain their decision in much more detail than one where the impact isn't so big. And this takes into consideration the fact that administrative law is a big area of law and encompasses all kinds of different interests. So the kind of decision that will be acceptable when somebody is denied a driver's license may be quite different than the kind of decision that that is needed where a person has lost their job.
Sorry, just to make, but we've got one more question that's come in from Bruce Hornsby. I don't know if you can see it or I can read it out.
So if an administrative decision maker does not give reason for a major departure from prior decision, does that become a ground for review based on the sufficiency of reasons? It's not based on sufficiency of reasons. It's based on reasonableness. Sufficiency of reasons at this point is out the window. It's all the question of whether or not it was reasonable. And so what you're going to have to look at is it's definitely vulnerable to judicial review. And what you're going to have to look at is it's a major departure, and then is it on what ground? What's the issue that they're departing from? If the issue that they're deciding is not sufficiently significant to the outcome, then it may not have an impact on the final decision on whether or not the court decides to overturn it, even if they're unreasonable in this aspect. But if it's a major departure, they don't give reasons, and it's on a significant issue, then yeah, that's definitely extremely vulnerable to judicial review. But as you can see, there's a lot of questions about how that applies as well.
And it looks like there's one more question there as well from Paul de Libero.
Okay, could you imagine a situation where brevity would pose a problem for decision makers if the essential elements are met? Facts, reasons, decision. There is often time, cost, pressure on decision makers to be brief in the reasons. Could a licensing decision be dealt with in a paragraph or less without inviting scrutiny? I can't talk about licensing, I don't know. But yeah, that's going to be one of the tensions, I think, coming out of Vavilov is how brief is brief enough? It may be there are some circumstances where the situation is so evident that very brief reasons could be provided, or where there are also decisions where people are making them every day and making tens of decisions or hundreds of decisions a week, all along the same lines or all following the same that come up all the time. And in that case, there could be briefer reasons with that really hit the basic elements. And of course, it depends on how complex the issue is. But it is, I think that's one of the issues that's going to come out of Vavilov is how does this apply to workaday and administrative decision makers who are making decisions on a routine basis. Of course, how often do those go to judicial review? I don't know either, but it's something to think about. So just going back to and finishing off the impact of the decision on the affected individual, one other thing that the Supreme Court said was if the impact is going to be harsher on the person than you would expect, or than is necessary, or than is within possible range, but is a little bit more on the outlier, then more reasons will be required too. And so that would occur in terms of, say, penalties, where you're imposing a harsher penalty. You'll have to justify it. All right, so that goes through all the legal and factual considerations. And again, if you're bringing it on judicial review, you're not going to have to go through everything in terms of setting it in front of the court. You pick what is applicable and go from there. All right. Now, going on, one of the vexing questions in administrative law is how do you apply one standard to the entirety of all administrative law? And as I said, and as you all know, administrative law is vast. So can one standard be applied to the guy who didn't get his driver's license, to the minister who's making a decision about use of resources that involves taking a look at different stakeholders, and to human rights tribunal? Well, the Supreme Court says yes, it is one standard to rule them all. They said reasonableness remains a single standard, and elements of a decision's context do not modulate the standard or degree of scrutiny by the reviewing court. Instead, the particular context of a decision constrains what will be reasonable for an administrative decision maker to decide in a given case. And so the way I read this is that one standard of review, when it's reasonableness, you look at all decisions in the same way. You don't give more deference to one kind of decision and less kind of deference to another kind of decision where the standard of review is reasonable. What can happen, though, is that the types of decisions that the administrative decision maker can make, or the kind of factors that they can take into account, can be expanded or can be constrained depending on the context. So the minister making the decision about access to resources, and who has all kinds of different stakeholders that they have to take into account, and who has the legislation that says that they are making the decision in the public interest, will have much more amplitude than even somebody who's making a decision about whether somebody should be administrated on humanitarian and compassionate grounds. That legislation, as it was several years ago, I haven't looked at it for a long time, was quite discretionary, but because of other factors, a person's discretion will be more constrained.
And we've got another question here from Shannon Emery.
Okay.
Just asking, so we no longer care about the level of expertise of the DM, for instance, Labor Relation Board versus a single adjudicator with no legal training deciding licensing issues.
Yeah, that was one of the things that that Vavilov has put to bed. We do not presume expertise. That's been a long time coming. It's been a long time that we've always thought, the legislators chose to give this to administrative decision makers for a reason, therefore we defer to their expertise. And Vavilov says no, but there is a caveat. What they talk about is demonstrated expertise. So where a decision maker shows that they have expertise in a certain area and applies it in a way that's reasonable, then the court will be deferential to them. But deferential on the same standard as the person without any training whatsoever. So it's a bit of a different way of approaching it. It's not about deference anymore. It's about showing what you know. And the layperson has to show it, and so does the expert. So in terms of the one standard, there's still clear, however, that the reasons, just like in statutory interpretation, the reasons will not necessarily look the same as those provided by a judge. Decision makers may incorporate the ideas and language of their highly specialized fields. And this is part of what Vavilov means in terms of showing their expertise. And so a decision can be unique and adapted to the situation. Now, I showed you way back in our time capsule, Baker, those notes, not just because they're mind-boggling, but also because those reasons, if they had actually been reasonable, would still be accepted today as reasons. So you can still have notes, and you can still have something adopted by the decision maker that's prepared by somebody else. What has to happen is it has to have that analysis. And what Paul was raising was, can that be in a brief way? Sometimes, and sometimes not. Okay. Now, it's here as well where we talk about the role of the record. The court does say that the record submissions of parties and publicly available policies may be reviewed to help explain something that isn't apparent in the decision. But the examples they give are pretty restrictive. So it's something that things that were decided during the hearing or during the course of the proceedings and isn't referred to in the decision. You can use the record to supplement the decision in that way and say, okay, well, that was decided during the proceedings, and the parties were clear about what the decision was. So the decision maker didn't refer to it in their reasons. That doesn't make the decision unreasonable. Another thing was where there's something that isn't quite as clear in the decisions as it could be, but if you put it together with the record, then it becomes quite clear what the decision was. Again, though, the parties have to know why, right? The parties have to understand it at the time that the decision maker makes that decision. So if it's during the proceedings, then it has to be communicated to all the parties. And what the record can't do is it can't fill gaps or correct the decision maker's mistakes. So in that sense, it's Lukash's decision, or the decision in Lukash. Okay, let's see. Next slide is, now, one of the things that was interesting was, and this actually probably goes back a little bit to what I was talking about before in answer to a question. Taking a look at some of the cases, I was interested to see how some courts adopted Vavilov in terms of the wording. And it kind of provides some interesting perspectives on the issues of what to do when you've got an expert decision maker and how you're reviewing their decision. So this case is not particularly important for any reason except that I found the language used by the court quite interesting. So Dr. Verma was a qualified dentist in India. He applied to practice in British Columbia. And because of that, he had to be assessed in a few different areas. He failed one part of the assessment. He appealed his failing grades to an appeals panel, and the panel confirmed the grades provided by his assessors. Then he applied for judicial review. And in discussing reasonableness, the court said, and this is reasonableness more broadly, the court said reasonableness is a deferential standard. Deference is particularly warranted in respect of essentially factual determinations grounded in observations, analysis, and expertise of the tribunal in question. As the majority observed in Vavilov at paragraph 93, in conducting a reasonableness review, judges should be attentive to the application by decision makers of specialized knowledge as demonstrated by their reasons. To recognize that deference is warranted is not to say that review is excluded in respect of factual assessments engaging the appeals panel's expertise in clinical evaluation. A petitioner may still attempt to show that the tribunal's factual findings are unreasonable on the record before the tribunal, though the persuasive burden on the petitioner is heavy in such circumstances. So I wanted to put the whole thing in because he does quote Vavilov and talks about the fact that you do have to do a factual assessment. But I found a couple statements interesting. This one. And the last sentence. So the first highlighted sentence says, deference is particularly warranted in respect of essentially factual determinations grounded in the observations, analysis, and expertise of the tribunal in question. But that's not what Vavilov says. You know, there is no more deference with regards to factual questions than legal questions. And what we have to do is, as judges and lawyers, is start reimagining this because we are so comfortable with the idea that deference is warranted in factual decision making. And in fact, Vavilov talks about it too. But Vavilov also says that there isn't more deference for one kind of thing than the other. It might expand in some instances the factors that the person can take into consideration or the conclusions that they come to. So it might be here that we give more deference to the decision makers because they have shown their expertise, and therefore the facts that they have chosen they have the ability to choose which facts are important. But I'm having trouble kind of trying to combine these two sorts of ideas and ways of thinking myself, even in saying this. And the second part, the sentence that was interesting was the last one, which says, a petitioner may still attempt to show that the tribunal's factual findings are unreasonable on the record before the tribunal, though the persuasive burden on the petitioner is heavy in such circumstances. And again, it shouldn't be any heavier than any other kind of persuasive burden that they would have. Now, what's interesting, and I'm not trying to diss this particular judge, because he actually then, when you look at the reasons themselves, he actually went into the factual observations in quite some detail and upheld the panel's decision. So I'm not sure he gave the kind of deference that he's talking about here. But and again, I think that what this shows is there should be a shift change by all of us in terms of how we're looking at these things. And it may not be as easy as we want it to be. And the other thing about this is, and the reason I picked this one is because it talks about, it's looking at expert decision makers. And there's an understandable tendency to say, well, I don't know anything about dentistry, how can I say that I know better than the appeals panel? And the majority is in Vavilov is saying you have to look at not only whether they say they're experts, but are they showing that they're experts? Now, we do have a little bit of time, so I'm going to go off a little bit on this whole expert thing. So, I mean, as I said earlier, and as you all know, expertise has been one of the hallmarks of administrative law, the principles of administrative law, that there's this presumed expertise because decision makers deal with their home statute all the time. They have all these kinds of these questions that come to them in the same way, much more frequently than before courts. And Vavilov has kiboshed that and said no, that you have to show your expertise. But what they didn't address, and I don't know if it's ever going to be an issue, but is interesting to me, is that the expertise comes not just because the legislature put these people in place and created this expertise kind of role, but in many circumstances, professional regulation is the hallmark of it. You're going to have people in their professions being the ones who review their fellow colleagues. And unlike that more amorphous expertise developed through use of the legislation, and because the legislature decided to put it in an administrative decision maker's hands, here what we have is the legislature specifically requiring that that certain people with certain skills be the administrative lawmakers, administrative decision makers. And so in that sense, I think that there is a legislative intent to say these people have expertise and you do have to pay attention to it. But I don't know what the majority or the Supreme Court will do with that, if they will ever do anything with that in the future. So that's my aside about the expertise of the decision maker. And that's the thing about Vavilov, it's just got so much in it that you could go down a rabbit hole with Vavilov and find different things. Okay, and now what happens when there are no reasons? The Supreme Court of Canada sure says, that's okay, you can still do this. And it provides an analysis about what to do, kind of provides an analysis about what to do when reasons are not given. But what you first have to do before you go into analysis is to determine whether reasons are required at all. So the first question is, does the legislation require it? If the legislation does require reasons are given, that's an automatic overturning. And then if legislation does not require it, you still have to think about whether or not reasons are required. So Vavilov did not say that reasons are required all the time. They still left that in the land of procedural fairness, and still allowed implicitly that the Baker factors would apply in determining whether reasons are required. And so just as a reminder, Baker says that there are a number of different factors that are used to determine whether reasons are required. And there's a lot of overlap, but it's not always, it's often unclear which factor applies where. And really, it's not super important which factor applies where, as long as you know what the important issues are. So the first has been shortened to the nature of the decision, but it's not really the nature of the decision. It's the procedure used by the tribunal or the decision maker in making their decision. And that one's fairly straightforward. It's how close is it to looking like a court? How close is it to a judicial proceeding? The closer it is, the more procedural fairness is required, more likely that reasons are required. The statutory scheme under which the decision is made, and that looks more at where the decision is in context of the statutory scheme. Is it a final decision? Is it something that can be reviewed? In those where it's closer to being final, where you're less likely to be able to provide more submissions, the more procedural fairness is required. The importance of the interest at stake in the decision relative to other interests, and that's a common thread in administrative law. We saw it in Vavilov, in sort of the substantive stuff too. If it's an important issue to a person, then there might need reasons. The sole basis upon which the Supreme Court decided that Baker required reasons was because being deported to another country was so important to her. The legitimate expectation of the parties, maybe in contrast to the importance of the interest at stake, legitimate expectations has kind of taken a back role in Baker, in procedural fairness. The idea is that where an administrative decision maker, and it's not so much the individual administrative decision maker as the body itself, has followed specific procedures. If they don't, that may cause problems. But it's a bit attenuated because it's not an absolute right, legitimate expectations. And then procedural choices available to the decision maker is what is set out in the legislation with regards to the process and what is left to the decision maker. So where the decision maker has more amplitude in terms of forming their own procedures, then it's maybe less to the fairness is owed than if there's something rigorous and set out in the legislation. But also, and this is going to be interesting post Vavilov, is Baker's talks about what procedures has the decision maker chosen, and you give some deference to that. But I mean, I would say that Vavilov is much keener on scrutiny of decision makers, so they may be much keener to scrutinize decision makers' choices of procedures as well. Okay, so we've gone through the Baker analysis and you decide, yes, reasons were required, they were not provided. The decision is automatically overturned because it's procedural fairness and standard of review is correctness. But if reasons were not required, then you proceed to review on reasonableness. And what you do at that point is you take a look at the record. And the Supreme Court talks about how often what will happen is that the record will show, will be clear about why the decision was made as it was made. And they refer to a lot of the municipal bylaw cases where there are debates and votes taken, and that provides sufficient understanding of why they decided what they decided and why. The court concedes that where the record is insufficient, there may be issues around trying to get to reasonableness based on the reasons. And they say that the outcome might be quite important at that point in terms of determining whether or not the reasons are reasonable.
It looks like we've got one more question here from Thomas Flavin. He's got, does legitimate connote reasonable, or does it signify expectations properly tied to the case as opposed to secondary objectives that are not necessarily meant to be part of the decision, but that a party might be concerned with?
So if you're talking about legitimate expectations, what legitimate expectations is about legitimate expectations with regards to process only. An example would be that an administrative body has always held oral hearings and suddenly decides in your case that no, a paper hearing is sufficient. You may have a legitimate expectation at that point that you should to have an oral hearing. Where something is clear cut in terms of that, there's an abrupt turn or pivot from an administrative body without any explanation, then that's very vulnerable to judicial review. But nobody is guaranteed any specific kind of hearing if it's not normally a part of procedural fairness. So if procedural fairness would not require an oral hearing, then you're not entitled to it just because it has happened in the past. It's legitimate expectations is a bit of a, you can get quite entangled with the legitimate expectations because if the court makes the tribunal proceed with a certain procedure that they shouldn't be required to do, then they're kind of going against the legislation. Not kind of, they are going against the legislation. So if the tribunal or the administrative body decides to change course and gives notice and provides and gives notice of it, then that's sufficient to remove your legitimate expectations. But it ultimately it doesn't have anything to do with the decision itself. It's the process. Okay. Okay, I've got 8 minutes, so let's see. All right, yeah, we're on the back end here. So having said all that, I'm going to go a little bit full circle or backwards, or anyway, we're going to revisit the past again to look at what's changed and to how we look at reasons. Newfoundland nurses. I think we can fairly say that Newfoundland nurses is put to the wayside. Newfoundland nurses said, if you recall, if the reasons allow the review in court to understand why the tribunal made its decision and permit it to determine whether the conclusion is within the range of acceptable outcomes, the Dunsmuir criteria are met. So the hallmark of Newfoundland nurses was deference. Now, Vavilov, the word constrained in that decision was used over and over again. It wasn't about whether the decision maker had discretion. It was what constrained the decision maker. Decisions, and you can see this in the decisions must be justified in light of the legal and factual constraints that bear on the decision. They're looking at it in a much more, they're looking at decision makers in a much more focused way. And one thing that I found super interesting is that the range of possible outcomes is not to be determined. So you'll see again in Newfoundland Nurses that says whether the conclusion is within the range of acceptable outcomes. And that language, that range of acceptable outcomes, is a hallmark of standard of reviewing a decision. Does it fall within what they can decide? But Vavilov said, no, you don't do that. You do not attempt to discern the range of possible outcome conclusions that would have been open to the decision maker. So I don't have a lot of time now, so I will skip why, but maybe you can think about why the court has ended that as a way of getting into reasonableness of a decision.
And Justice Wenckebach, there is another question in the chat box, but if you want to get through the rest of your slides and then see if there's time to come back to it.
Yeah, that sounds good.
Okay.
Okay. All right. I've got 2 more slides. And I thought it was interesting to compare Vavilov to a decision from 1998 that was taken up a lot by the federal court. And basically, as we know, Vavilov says that you have to take the evidentiary record and the general factual matrix that bears on its decision into account. The decision maker does. And failure to do that, failure to explain how it applies, can impact whether or not the decision is found to be reasonable. And this decision from the Federal Court of Appeal, Cepeda Gutierrez of 1998, says basically the same thing. And Cepeda Gutierrez was decided before Baker, and so it was based on a reasonableness basis analysis. But then it got subsumed into adequacy until 2011, where everything loosened up again. And now it looks like we're back to 1998 and the federal court analyses of reasonableness. But don't use them, use Vavilov, and if you're going to court. And again, just to look at what you need to do or what the federal court said you needed to do for adequate reasons is basically the same as what Vavilov says you need to do for adequate reasons. But then Vavilov adds more to it and puts the substantive analysis into it as well. So in some ways, I wonder if we're back to adequacy of reasons, but on steroids. In the end, I think it's fair to say that the Rosalie Abelian approach to standard of administrative law generally is gone. I think that we've got a much more legalistic approach, and that's going to be interesting to see how it plays out with regards to decision makers. And as I said, I think we have to look at how we talk about reasonableness, and it's a big shift in terms of the approach. And it's not about degree of deference, but it's something else that will, I'm sure, become more pithy as we go along. So that's that. I don't see that last question.
Oh yeah, it's in the chat box actually. Instead
of okay. Can you read it?
Yeah, so it's from Paul Batten. If there's no statutorily defined decision-making process or rules, do we just revert to common law procedural fairness rules when assessing the process? Can it be assumed that if there's no statutory process in the legislation, the legislature intended to leave it up to the decision maker, or that it's the common law procedural fairness steps that should apply?
Well, there's going to be a mixture of both. So there's certainly the fact that the legislature left it up to the decision to the administrative decision body suggests that there should be deference with regards to how they have constructed it, how they have determined their own procedures. And Baker still applies in that way. We'll see down the road. But it will be still subject. I mean, that is always subject to the common law rules about procedural fairness. So if Baker is the perfect example. Decisions hadn't been made as a rule, as a general rule, in agency decisions, and there was nothing in the legislation that described it. And in fact, there was the legislation was quite discretionary, but the Supreme Court said procedural fairness, common law procedural fairness requires in this case that reasons be provided.
Well, I think it's 1:30 on the dot, so that is perfect. Maybe we'll wrap it up here. But I just want to say thank you so much, Justice Wenckebach, for sharing your thoughts and analysis on Vavilov and breaking down how it's impacted the area of administrative law and how reasons are going to be considered in future post-Vavilov applications for judicial review. So it's a complex area, and it's fantastic to get your thoughts and insights on it. So thank you. Yeah. And thank you so much, everyone else, for participating.
Thank you. And thanks for your great questions.
Yes, very good questions. And we'll follow up afterwards just to make sure we get a copy of the slides sent out to all the participants as well.
For sure.
Yeah. Okay.
Okay.
Thanks very much, everyone.
Bye.